Hi all, how are you? You have been muted. Samantha, Reece from Australian Apartment Advocacy, and Amanda Farmer. Obviously, what we're trying to do is, because if we have too many people come into the meeting at once with everybody's microphones on, then it does distort some problems. So what we're going to do is mute everybody, but I am going to suggest that if you look at the bottom of the screen, if you hover across there, there's a chat button. So if you have any questions as we go through the session, please type them into the chat button, and that way then we can kind of vary those questions across to Amanda. So Amanda, thank you very much for joining me today. We'll get started. So tell me, you sent me this fantastic biography about yourself, but I always like to actually ask that person to speak about themselves. So why are you in Strata, and why do you love Strata, and how long have you been doing your legal, kind of like prowess with Strata?
Yes, well, thank you very much for having me here today on your webinar. It's lovely to see everybody. I kicked off my career in Strata, if you like. I was actually a Strata manager's assistant when I was at law school. It was my first office job, and I worked as a part-time assistant. It was my first exposure to Strata. It's how I found out, what is this word? What is this thing? Oh, it's apartments. This is what Strata managers do. And then I got through law school and I started to work for a lawyer who also did some Strata law. And I thought, hey, this is interesting. This is different. It's challenging. It's hard and can be complex. It seems very niche, but can also be quite broad. We're looking at contracts. We're looking at debt recoveries. We're in the local court with small claims. We could be in the Supreme Court. We can be dealing with developers and councils and washing, and then pets, and then all sorts of different things, and people and their lives. And the legislation has never, I think, across the country, and it's actually kind of getting worse as we get more sophisticated in our homes, never quite kept up and never quite covered all of the problems. So from a lawyer's perspective, you want to be challenged, you want new interesting things happening, and I think Strata is just that place, and has been for me. I have been practicing in this space specifically for the last 7 years with my own legal practice, but definitely involved in the sector for 15 odd years, right back to my experience as a junior Strata manager's assistant.
Amanda Farmer certainly does run also her kind of like podcast, like Friday afternoon session. So I'll get Amanda to talk to us more about that. If you're interested in actually receiving that information, actually partaking in that Friday afternoon session, then please let us know, because you cover all kinds of things, don't you, in terms of what's happening within Strata. You can hear my dog barking. Sorry, one of the plights about doing this from home. Give me a second. I'm just going to go and shut that.
That's all right. You might hear my dog soon. And I am in Strata. So I have a Strata dog. His name is Louis. And I also have a Strata child. His name is Callum. He's 7. And I can hear him. He's finishing up dinner and he's chatting away back there. And soon he'll be running past here. So, it's all happening.
I was going to say, do you have a Strata husband? So
I have a Strata husband. I do. Thank God. Thank God.
So I've just got a quick PowerPoint I've put together. So we're going to actually just run through this as a lead up from the beginning of the session. So there we go. Look at me being all tech and everything. So Amanda, we're talking today about pets and apartments, and that's one of the top calls I get actually from people. They call about their Strata managers. They call about some issues they're having with their builder or developer. But the other thing I get a lot of calls about is pets. So, why are we kind of like in this position where we kind of like don't seem to be catching up with society in the terms of, obviously pets are a very common element in a people's home. Why is Strata behind slightly, do you think?
Yeah, you're right. The community culture, community standards, as our court's been saying, have changed reasonably quickly, I think, within the last few years. The role of pets in our lives, lots of research coming out about how good that is for not just our physical health, but our mental health. This year in particular, we've all heard about so many people welcoming pets into their family because we're home, and that works when you've got a new new puppy and we're looking for new ways to connect. So that's definitely been one of these fast changing cultural community aspects that I have seen. And then we combine that with our strata complexes, where we've had this attitude, which I like to call old-fashioned, because I like to think that maybe it's changing, of we make the rules, we're in charge, we set the standard for our community, and that's what it is. You come in and that's what it is. And it doesn't matter if the standard outside the community changes. That's part of the reason why we want to be in Strata, because we can make our own rules. And I think that's a hangover from the company title system that we've had in Australia before we had Strata title, where you bought shares in the company and then the company ran its own show in terms of the building. You had the right to use airspace in return for your shares, and that company could have some really strict rules about who could live in the building, whether you could have tenants or not have tenants, approving sales to certain people, whether there could be kids or no kids. There was really no restriction on that kind of rulemaking power. We've got more of those restrictions now that we have strata title legislation, but I think this restriction on pets and this attitude towards pets is a bit of a hangover from that time when we had that company title system. We were a bit more strict, and we're seeing this clash now between this fast changing community attitudes towards keeping pets and that old-fashioned attitude towards controlling our communities from within.
Well, correct. And, we're talking about, the benefits of pets. And certainly I know that if you get into a lift and someone's got a dog, invariably a conversation gets started, right?
Yep.
You ask the dog's name, you ask what kind of breed they are. It starts a dialogue which might not normally happen between residents within that building. And I think it actually creates a bit of a community, and certainly it's great company. COVID, as you said, has been a catalyst for a lot of people to get a pet. And, it does encourage you getting out of the building, going in and having fitness. And as I was talking to Amanda before, like in America, they've actually got emotional support dogs. So if you actually need an emotional support dog, you actually can ring up and order one of these kinds of, support dogs. And I guess, why are we not actually being kind and allowing pets to be in strata? What's going on with it, do you think?
Yeah, we're hearing a lot at the moment, and I know we're going to get into this court case that we've had in New South Wales, a lot about this fear around the erosion of our democratic right to decide what we do in our apartment buildings. It's coming up a lot in the media over here. There are some owner advocacy groups who are using that kind of terminology. And I've said fear because I believe that's what it is. When you're a lawyer in this space and you're reading the cases and you're understanding the legal principles that are being established and why these decisions that are allowing pets are being made, it is not at all a challenge to, a risk to anybody's democratic right to decide what does and doesn't happen in their communities. We still have the democratic process. We still go to general meetings. We still vote for what we can and can't do. Sometimes it's a simple majority. Sometimes it's higher than that. Nothing about these cases has changed that position. We have always had in our Australian legal system and pretty much across the world, if you're in a developed democracy, protections in place for minorities and protections in place to make sure that there cannot be what our Court of Appeal has now called a majoritarian dictatorship. So sometimes, even when you have a democracy and the democratic process, the majority can get things wrong because they're simply not listening to or aware of or care about the needs, the real needs of the minority, and the minority is being walked all over. And we have protections and provisions in our legislation, not just strata, lots and lots of different types of legislation that we have in our country to protect people like that. And that is good, it is right, it is necessary, and it is not at all an erosion of anybody's democratic right.
No, and certainly, unfortunately, I have seen a number of council of owners or body corporates or, even council of owners that we have here, where unfortunately the chair actually does think it's an autocratic society and not a democratic society. And, I've actually had to say to some people, excuse me, but you're here to represent the people, not necessarily just what you want. And it's very difficult if you have one of those on your council of owners or board of corporate or owners corporation, because they tend to not actually listen to what other people have to say. So obviously, if we think about drawbacks with pets, obviously, you know, the idea of noise, barking dogs. And I saw something the other day which actually said that you should be choosing a dog for the apartment, not based on its size, but based on its breed, which I think is a very wise thing, because I have a Jack Russell with a pug. It's very small and cute, but Jesus, he barks. So I'd hate to have him in an apartment. I had to up the dose of his Prozac. But, you know, so I think, you know, there's definitely some drawbacks, but really for me, I think that having a dog in the community brings more to it. And as you said, this new Cooper case that just was actually heard recently talked about the court has found that banning animals breaches Strata scheme legislation, which provides that bylaws can't be harsh, unconscionable or oppressive. So how do you feel about that?
Look, I feel I wear two hats in this. I've told you earlier that I live in Strata and I have a dog. So I wear the pro-pet Strata dweller hat that says this is a fabulous decision. I think pets bring so much good to our lives, and you've had that up on the slide. So for that reason, I think it's great. Then I put my lawyer hat on, and I believe this is a sound legal decision coming out of the highest court in our state here in New South Wales. And we had some legislative reform in 2016. Our new Strata Schemes Management Act started, that's 4 years ago, and it introduced this concept of harsh, unconscionable or oppressive bylaws. And for the first time, we had this new restriction in our legislation that said a bylaw cannot be harsh, unconscionable or oppressive. If it is invalid. And so for a number of years, we've been working through in different cases and at different levels of our legal system, what these words mean: harsh, unconscionable or oppressive. They're a mouthful. And no one was really quite sure what they meant. Even the lawyers weren't sure what they meant in the context of Strata and in the context of bylaws. And pets was always going to be one of the biggest, most important tests of these words. And what happened in the Cooper case was that at the first application, the lowest level of the tribunal decided that the bylaw, which was a blanket ban on the keeping of any animals in the Horizon building in Sydney's Darlinghurst, except for guide dogs or assistance animals. They didn't ban that, but everything else, blanket ban, no need to, no application process, none of that. It was just a blanket ban. The lowest level of the tribunal said, yes, that is a harsh, unconscionable or oppressive bylaw. It's invalid. The Owners Corporation appealed to the appeal panel of the New South Wales Tribunal. The appeal panel said, actually, there's nothing wrong with that bylaw. It's fine. You can have these blanket bans on pets. And then Joe Cooper took the case to the next level, which was the Court of Appeal. And the Court of Appeal said, yes, a blanket ban on pets, this particular ban in this particular building is harsh, unconscionable or oppressive, and it is invalid. And they gave a number of reasons why they felt that that bylaw fell into that category.
So it's interesting because in my apartment complex, we allow pets, and we've actually now got a system whereby when people basically want to apply, they can do it through our Strata manager. We've actually got a process, they tick it off, and we've even got a tag. So we can actually, as a council of owners, when we're actually in the building, if there's a dog without the tag on, we can actually say, has your dog been registered? So,
Nice.
you know, there's actually a bit of a, you know, transparency around that. But, you know, I've got some questions here, so I'm appreciative of the comments coming in. You know, someone here has said that they've been attacked by a dog in the lift as it was not on the leash, as required under the bylaws. You know, that's the thing, isn't it? It only takes one person to kind of like abuse the situation, like having poop in the hallway, that it makes you kind of like feel a bit anti the whole thing. How do we get around that situation where someone has obviously been outside the breach of the bylaws?
Yeah, that's really awful. I can see that's under the name PSAM. So sorry, PSAM, that happened to you. That's a horrible experience. Absolutely, we need, I advocate for strong pet bylaws that allow pets on application. The Strata Committee must consider the application, not unreasonably refuse it, and impose reasonable conditions. And definitely one of those conditions is, as you say, it should be on a leash when on the common areas. I hope that there was some recourse taken against this owner who was clearly in breach of the bylaws and has caused that harm. I'd be interested to know what your building did about that. These kinds of situations have certainly been brought to the attention of the tribunal and the court when buildings and owners are arguing these issues. So buildings have said, well, what about situations like that where a resident might have a fear of animals because of a past experience, or there may have been an incident where an animal has been violent or dangerous, noise, damage, disturbance. And what the court has said in New South Wales is all of that absolutely could happen, but banning the animal, well, banning any animal full stop without actually considering the case-by-case application is not the answer. You can regulate the outcomes of having the animal. You can deal with noise through a noise bylaw if you don't have a detailed animals bylaw that mentions noise. You can deal with damage to common property through other provisions that are in all of our legislations, codes across the country. You can deal with mess under the different parts of the Act. You can deal with nuisance. You manage the outcome of the animal, and theoretically so, and I acknowledge that this particular circumstance that's happened to you in the lift, the blanket ban may be administratively convenient and may be catering to the worst case scenario or the biggest fear, but that is not at law a reason to ban something, and it is in fact an example of being harsh, unconscionable or oppressive.
Well, certainly our new Strata regs have just changed, and we have the same wording as you do in New South Wales. It's interesting because no one as of yet has taken a pet situation to SAT, which I guess is where it would go. But I guess, you know, if it was to, was your impression be, since we have the same wording in our Strata regs, that someone actually would then have some kind of leverage based on what happened in New South Wales?
Yeah, absolutely. We have a lot of similarities across our legislation, both with WA and then also with Queensland as well, and somewhat in Victoria. And we have definitely seen in the past our respective tribunals looking at other jurisdictions with that similar terminology and adopting similar reasoning, and those cases not being binding. They're not binding across jurisdictions, but they are persuasive. We've certainly seen that. You had a very popular, or in the legal circles, a popular short-term letting decision, your Sarissa River decision, which was now 3 or so years ago, about the bylaw making power when it came to banning short-term letting. We have the same terminology in our legislation in New South Wales. And indeed, that case has been mentioned in similar cases here in New South Wales as well. So I can absolutely see that playing out over there for you too.
Yeah, I think and so it's interesting because I have actually got someone here. I'm in WA with new legislation that's been untested yet. I manage a complex that does not allow more than one pet and nothing over 10 kilos. I don't understand that whole 10 kilos rule, right? I have an owner in the defence court who is a dog handler. The council of owner will not approve his dog to live at the scheme as it's a Belgian Malinois, which may be considered to be similar to a German Shepherd. This is a highly trained dog and will likely be euthanized if it cannot live with the owner upon its retirement. Should I advise him to test the bylaw at SAT? Well, I guess if he's prepared to pay the costs, but you can actually take these matters to SAT without a lawyer, can't you? So it is possible for you to kind of like challenge this. I'm personally someone who always does believe in challenging the norm. I don't know if that I should be saying that. I'm sure there's a disclaimer somewhere that I need to have at the back end of this PowerPoint for that exact purpose. But what would you say, Amanda? What's your bet on this situation?
Yeah, look, I'm seeing a lot of this in New South Wales at the moment. I've got a lot of clients and would-be clients approaching me, asking very similar questions. Now that we have this case in New South Wales, what about my situation where I can't have this particular dog, or it's a certain weight, or it's a certain breed, or we can only have one? Should we be challenging this? My answer is always, strangely enough for a lawyer, we don't want to jump headfirst into litigation, that's for sure. What you want to be doing, first of all, is talking to your council of owners, to your strata committee, and saying, hey, I'm not sure if you're aware, but we have a case that's just come out of New South Wales, and it's based on this section of their legislation. It's section 139 here, and we have the same wording in our legislation in WA. And it's my understanding that we need to start thinking carefully about if we have a ban, whether we should have a ban, and if we have restrictions, whether those restrictions might be harsh, unconscionable, or oppressive. And I'm in a situation, this is what you might be saying to your council, where you haven't let me have had this particular animal. I've read the Cooper case, and I can see that what we need to be thinking about is regulating the outcomes of keeping the animal, not the fact of keeping the animal. So can we, Council of Owners, have a chat about, if I was able to keep the dog, what kind of assurances can I give? What conditions can I agree to? What are there places that maybe I don't take the dog, keeping the dog on the lead, making commitments about the behavior of the dog, and if there's any incident, then that's it, it's all over. How can we find a negotiated solution? Because I really don't want to apply to SAT and test this, but this is a member of my family. I think I've got the backing of the law here, and it's a place that I will end up heading if we can't work it out. So that's your first sort of softly approach, if you like. And that's what I'm telling my clients here. And we're in the jurisdiction where we've got this case. If you haven't tried that approach and you're thinking about this kind of a challenge, that's definitely where I would start.
Good advice. And yes, we are recording the session, so don't worry if you're trying to frantically write down those comments from Amanda. You will be able to replay the video down the track and actually get that word. So let's say you mention this to your council of owners or owners corporation, body corporate, they're still not budging. Could they in a way say, we're not going to do a blanket ban on pets? You can apply, but then they actually reject every application. Now, would that then become the same as per the wording? You know what I mean? Like, they're not banning.
Oh, yeah.
But they're not actually approving any pet applicants.
That's
Is that
right.
not the same?
Yeah, usually the words that are used, and I know you've got your model bylaws in your legislation similar to what we have here, and a number of strata companies will have a bylaw that says applications can be made to keep pets, and such applications may not be unreasonably refused. And generally the way that a tribunal will see it is, if there is simply no response to your application, then that's considered a deemed refusal, and no response is no reason. So that's on its face unreasonable. And then saying things perhaps like you can't have the dog because we're worried about mess, or we're worried about noise, or we're worried about damage to common property. In my view, I think all of those would be unreasonable reasons, because as we've said earlier, we can deal with all of those outcomes in other ways. We can deal with them by having conditions in the bylaw that require you to attend to those things, to fix any damage to the common property. I draft animals bylaws that deal with, for buildings who are really worried about this, want to be really particular. We say things like, if there are 3 noise complaints within a period of 3 months or 6 months, or whatever the building wants to say, then we've got to start talking seriously about rehoming the animal. If you're trying to resolve a dispute and you're trying to find a way to avoid having the tribunal come in and say, this is the decision, this is the law, and then having that apply across the board, you are far better to negotiate a bespoke private agreement with your strata company, and something you are comfortable with or least uncomfortable with, and the strata company is least uncomfortable with, and problem solved without having to go down that path. But yes, unreasonable refusal is a term that you'll see that does come up a lot in all sorts of bylaws, and you may see that more and more in Western Australia as we start to have the effect of this case filter through.
Yeah, and certainly in our building, we have a lot of security on each floor in terms of CCTV footage. So you can bet your bottom dollar that if someone does not pick up after their dog, they certainly do get a breach notice from the strata manager, because the CCTV picks up that, situation. And
Good.
listen,
Yep,
mistakes happen. We've all had mistakes, but ideally what you want to do is be considerate to your neighbours and just do what you would expect anybody else to do, right? So pick up your mess and clean up your mess, really. So have you heard of, well, so you said you've been obviously approached now by a number of people. Have you been surprised at how many people have come out of the woodwork since this case was heard, in terms of then, was this an underlying issue that we hadn't been addressing?
Oh, 100%. It is, it has been a problem in our legislation for quite some time. And I say problem quite objectively, I hope, because the way that legislation should work is that it should be reflective of community standards, what people want, the way people live, the right thing for our society to keep it ticking along, both in a way that's productive, but in a way that's also keeps people happy. Now, when we see, and this is not unique to pets in strata, but when we see a lot of litigation about a particular issue, it means that our legislation is not working. It is not reflective of what the community standard is. There's been some change in our culture that's not recorded in the legislation, or the legislation is now opposite to that. And we've been seeing this in New South Wales for years when it comes to pets in strata. Quite a few applications through our tribunal, a very common issue in strata, a cause for complaint. We say the 3 Ps, pets, parties, and parking. They're the things that bother us around the country. So when we, as our politicians, our elected representatives, are the ones who we charge with the task of hearing this, of seeing this, and then of taking the concerns to our lawmakers in Parliament and changing the law. Now, we kind of did this a little bit in New South Wales when we had our 2015 legislation. We had a model bylaw that sort of prioritized the application process and played down the ban. But we did not have a section that said that bylaws can't be unreasonable, like Queensland has. And we did not have a section that said you can't ban animals. I think we're going to see that. I think we've got that coming in New South Wales. There is an amendment before our New South Wales Parliament at the moment saying that bylaws cannot purport to unreasonably restrict animals. There's a bit of conjecture about whether that's going to get up. We probably need some different wording and a little bit more time spent on that drafting. But I think absolutely it's coming. I was working with a lot of owners before the Cooper case was decided, who were waiting on that decision. And, I've been sending out my broadcast emails since then, letting everybody know what's happened. And of course, the question now is, if a blanket ban in Joe Cooper's building, the Horizon, is invalid, does that mean the blanket ban in my building is invalid?
Correct. You have to think so, right?
Well, yes, is what I say. But the fact is that the bylaw still exists for these other buildings. It's still there. It hasn't had the tribunal. Only the tribunal can make a declaration saying a bylaw is invalid. But what I say is, well, the building has to play it out. You bring your dog into the building. They say you're in breach of the bylaw because there's a blanket ban. They take you to the tribunal and they say, this owner's in breach of the bylaw. There's a blanket ban. They won't remove the dog. The tribunal's going to say, this bylaw is in the same terms as the Horizons bylaw. The Court of Appeal, a superior court in New South Wales, has determined in this case that the Horizons bylaw is invalid. Applying the rules of precedent, your bylaw is also invalid. It is harsh, unconscionable, or oppressive. I mean, that's just the way that it's going to play out. I'm in communications with a lot of strata managers at the moment for these owners I'm acting for, explaining that to the strata manager and by extension to the committee, and saying, why are you bothering standing in the way? Convene a general meeting, convene a general meeting, change your bylaw, because otherwise we'll end up in the tribunal and you won't have one.
I'm surprised anyone would stand in the way of you, I tell you.
They try, Sam, they try.
I totally underestimate you then, darling, because once you've got that legal backing, there's no stopping you. And I think you just said it very succinctly, right? So I think the good news for pet owners around Australia is that now we have seen a court precedent You cannot do a blanket ban on animals. If it's applicable for, like you say, Horizon, it's applicable for any apartment building. And, you know, I'm looking for an apartment at the moment to move into at the end of the year. I may actually just do as you suggested and move in with my dog and then see what hell breaks loose. And then we'll go from there.
And then give me a call.
So before we finish up, is there any other questions from the community? Can individual offensive dogs be banned? We've got a question there.
Yeah, and I saw your comment earlier, P. Sam, about your experience, and the building manager had issued a breach notice. The owner didn't comply. It recurred again. In a building that has, and this is why this process, this clear bylaw, having a clear bylaw that sets out an application process and says what happens to the pet and to the pet owner when these conditions are breached. And I think absolutely, if a dog has been violent, has damaged property, has caused personal injury, then it should be in your bylaw that that's a reason for the dog to go. Sorry, but I mean, I'm not going to put up with a dog that causes physical injury to anybody in my home.
No.
But if you have the backing of a properly drafted bylaw that says these are the conditions, and if these conditions are breached, then the dog has to go, then that's what you can rely on. I also think if you have an owner who has a bad history, so this owner who perhaps has had this violent or dangerous animal, and then the animals had to go, and then they come back 6 months later with another application and say, oh, well, now I've got another dog. I really query there whether a Strata council who's considering the application, it might actually be a good reason to refuse permission for that particular owner because they have this history of not being able to control their animal, or of having dangerous breeds, or I think that's a really interesting situation. And but a Strata council would have to be very clear about the reasons why it was refusing that application, and would need to say, well, on the 3 occasions in 2017, this happened, we issued notices, you didn't comply. Unfortunately, your credibility with us is not great, and that could well be a reason to refuse approval for future.
And I do think it comes down to bylaws, because you can write a bad bylaw. We've all seen those, right? Usually about short stay. So I've seen bylaws written where no one can stay in the apartment for less than 3 months, but then someone wants to go to hospital and they can't have their granddaughter come in but house sit the apartment because it's below 3 months, right? So that, I think, is key. If you want to put a bylaw in, it is well worth talking to a Strata specialist about what that bylaw should read or say. So I have a message here from Jan. I have a couple of queries. I'm about to move into an apartment and have 2 small dogs, which are apparently acceptable. I'm interested in knowing which pets are generally allowed to go into apartment developments. Well, typically it's been less than 10 kilos, hasn't it, right?
Yeah. And I think where Jan's asking as well, where pets are allowed to go: lifts, lobbies, car parks,
communal areas.
I was reading, actually, I was looking at the Victorian legislation, just to your question there, Jan, recently, and they've got a decision from 2016 that said pet bans were essentially discriminatory and they can't have discriminatory bylaws in Victoria. And the member who decided that case referred to exactly what you're talking about: areas like pools, gyms, communal places. It may not be illegal or invalid to ban a pet going into those areas. And just tapping into the Cooper case on this, what the court said is we need to be thinking about what job the bylaw is doing. Is the bylaw there for the benefit of other owners and occupiers? And a blanket ban just isn't. A blanket ban is there for the benefit of the Strata Committee, the Council of Owners, to make their lives easier and to make the job administratively convenient. So they can just say, that's it, it's a ban, we don't have to think about it. But a bylaw that sets out where animals can and can't go, perhaps, yes, to another point that's been asked, where dangerous dogs are not permitted, that is, in my view, a bylaw that is for the benefit of other owners and occupiers, because it's protecting them, and it can be one of the only ways to protect them. So blanket bans just don't do that. carefully drafted bylaws with clear conditions about where animals go, what kind of breed of animal, but be very careful about that. I mean, I'm not an expert. I don't know what dogs are
Well, there's
dangerous or what
definitely
are not.
banned dogs. There's banned dogs, and
Yeah.
they're listed, by the Australian government. So you can definitely get that. But I agree with you. I do think that there's a certain place and time for dogs, and I don't know if around the pool is definitely one of those locations, or the gym.
Yes.
And
Yeah,
typically, when
indeed.
I have seen people with dogs, they're usually going in and up and down the lifts on their way out, to take the dog for a walk. I actually do know of an apartment here in WA that actually has a dog walking area on the rooftop terrace, and they have like
Oh,
a dog
nice.
play area.
I
So
love
there's
it.
definitely an embracing of dogs, which I think is really smart, right? Because
Yeah.
certainly if there's a strong dog population with the owners, it does actually make a decision about whether or not they'll buy an apartment based on
Oh,
whether
yeah.
or not their dogs can go in.
Yeah.
All right, so I'm just conscious of the time. I'm very grateful, Amanda. Is there any kind of like final comments that you would like to make or say before we kind of like wrap up?
Well, I want to say thank you very much for the opportunity to be here tonight and talk to you all. I'm very pleased to hear there'll be a recording. So thank you for making the time on what is it tonight? A Tuesday? No, Tuesday already. I was telling Sam how busy I've been and I've completely lost track of my life. But absolutely, this is the kind of stuff that I'm talking about on my own podcast every week. If you wanted to find out more about that, it's over at yourstrataproperty.com.au. We've been talking about pets for a long time, and hopefully we'll be talking about some other of our most pressing issues in Strata again soon as well, getting ready for 2021.
Yes, well, it's certainly be interesting to see what happens now. As you are probably aware as well, Amanda, I just recently launched a 4-part education kit for apartment buyers and owners with Minister Tinley, our Minister for Housing, and also our new Lord Mayor for Perth, Basil Zemplis. That's also on our website, so waaa.net.au. If you're interested in buying an apartment or you are an apartment owner, that education kit is now there free of charge. So please buzz over. And I am in the process, so I did actually just last week write to all the politicians in the East Coast asking for them to work with us in creating something of a similar ilk as well in each of the states. Yeah, because I think that would be really worthwhile. Yeah. And on another note, we are also in WA creating a dedicated apartment awards program, which we're launching next February. I'm very excited because we've actually put a people's choice in the categories, which is for council of owners to nominate their own building. And it deals with things like, have you got communications? Do you do social events? Have any of your council of owners done education? How are you going with your travelling in terms of your financials? Have you put your 10-year maintenance plan in place? And those kinds of things. So if you're an apartment owner and you think that your building deserves to be nominated, more information about that will be coming out soon. So we can't do this without our sponsors. Thank you very much to all of those organisations that help me actually do what I do with the research and education. So Amanda, any last comments for people who are watching this or will be watching this and thinking now's the time to strike? Do you agree with them on that?
Now's the time to strike with your pets?
Yes. Well, not the strike in terms of then getting your pets into the apartment building.
Yes, I think so. I think at times they are a changing, that's for sure. And we're going to see more of that into the future. I want to commend you, Sam, for all of your good work that you do in this space and have done for some time. You are another one of these incredibly energetic women that we come across in Strata. And I think your kit looks amazing. I would love to see that come over to the East Coast. And thank you for being that advocate there for apartment owners, apartment dwellers. It's something that I think is missing a lot, from our space, this positive energy. When I interviewed you for the Shared Space Summit, it was your positive energy that I talked about, all the great stuff that comes with living in Strata. I know the people on this call, I probably don't have to tell you, but it's important that we continue to share that message and continue improving our communities and welcoming our furry friends, I think is a step in that direction.
Oh, I totally agree, because a community is, in fact, as I said in my booklet, when you live in a vertical community, you just have to be just as conscious if you actually were living in a horizontal street, right? The same situations occur. You have to be courteous, you have to be considerate, but most of all, you have to be a good sharer and kind and somewhat tolerant. So, you know, please, let's look at how we can get those dogs into the apartment building, because I think it will only create a nice energy within that building. And if there's any troublesome pets, well, that's when your bylaws come into effect. And generally they are the minority, aren't they? Not the majority.
Oh, let me tell you, I don't have any troublesome pets on my books, but I got a lot of troublesome residents, right? People, human beings. The dogs are the least of our problems.
Well, on that note, Amanda, I think I couldn't finish it in a more perfect way. Thank you very much for joining us today. Thank you for all the work that you're doing in the legal field, and your, you know, podcasts on a Friday are great, and certainly they're well worth tuning into. So I will supply those details when I send out the link with this video as well. So Amanda, thank you very much. You're obviously in Sydney. It's a lot later there than it is here in WA.
That's okay.
I appreciate your time and good news that you've given us.
Thanks, Sam. Thank you, everybody.
Take care. Bye now.
Bye.
Bye. Thanks, Amanda.